What are your rights if the police want to stop and search you? One fundamental point that I want to emphasise at the outset is that the police can stop and question you at any time. They're entitled to speak to you, but in order to search you, very specific provisions have to apply. This video isn't a debate about the use and abuse of stop and search, but a checklist and perhaps a way of understanding what the police are entitled to do and what you're entitled to know and have upon being searched. This isn't advice, it's not advice on how to impede a stop and search. If the police have reasonable grounds to search you and begin the process of that search, and you start quoting this video to prevent the search, you're not going to get very far. In fact, you might possibly aggravate the situation, and it might result in the police using reasonable force to enforce the search. So what you can do and what you're entitled to do is check they're doing their job correctly and you satisfy yourself that you're being treated lawfully. The best way to remember your rights and the law on stop and search is the acronym GO WISELY. Go wisely. Let's go through that. G, grounds. In most cases, the police must have reasonable grounds to suspect that you might be involved in the commission of a crime or that you're in possession of a prohibited item which can include knives, weapons and drugs. Now, their reasonable suspicion can come from intelligence or something they've witnessed themselves. The smell of cannabis is often a reason provided by the police as the basis for a search, and it's not good practice for the police to base their suspicion on smell alone. And you are entitled to ask why they've stopped you and why they want to search you. They should certainly be telling you the reason. The search cannot be based on instinct and instinct alone. There is another type of search called a Section 60 search, where police don't need reasonable grounds to search you. A Section 60 order gives the police the power to stop and search anyone within a designated area or location. It's a special search power that's in place for up to 24 hours, where it's believed that serious violence may take place. For example, gang retaliation, or more recently during the far-right protests in London last year, or the Notting Hill Carnival. But that's quite unusual. So G is grounds, go wisely. O is object. The police must declare the object of the search. They must tell you what they're looking for. W, warrant card, and I, identify. Go wisely. W and I. The police have to identify themselves to you, who they are, their badge number, and tell you what station they're attached to. And you can ask to see their warrant card if they're in uniform. If the police officer's in plain clothes, they must show you their warrant card. They must tell you which station, this is S for station, they must identify which station they are attached to. E, entitlement to a copy of the search record. You're entitled to a copy of the search record. It's like a receipt of your search that has the details of your search. For example, the date, the time, the location. You're entitled to a copy of this as soon as reasonably practicable. They're not required to provide you with the search record immediately. It's as soon as reasonably practicable. L, legal power. What search power are they using? The officer must tell you which law they're searching you under. For example, they have reasonable grounds to believe you're in possession of drugs. They must tell you that they're searching for illegal drugs in that situation under Section 23 of the Misuse of Drugs Act. Quite often, officers will say they're searching you under Section 1 of PACE, the Police and Criminal Evidence Act, and this is another search power they can use. Why? You are being detained for the purpose of a search. Before the actual search begins, the police must tell you you're being detained for the purposes of a search. Go wisely, that's the acronym. Grounds, object, warrant card, identify, station, entitlement to search, or entitlement to search record, legal power, you are being detained. So what else do you need to know about a stop and search? We often come across videos of the police carrying out searches, but it's usually the ones where police have resorted to force that make the headlines or the latest Instagram post. Can the police use force in a search? Yes, they can. They can use reasonable force to search you. Reasonable depends on the circumstances, but if you resist, it might lead to an arrest. Can the police strip search you? Yes. If the police are to conduct a more thorough search, so something more than the removal of a jumper or a t-shirt, then they can do that in the back of the police van or somewhere out of public view. If they're seeking to remove your clothing and conduct a strip search, a full strip search, they must take you to a police station or a police tent out of public view, and the search has to be carried out by an officer of the same sex if there's going to be a more intimate search. Now, your Perhaps wondering what's your recourse if the police fail to do all the things I've mentioned. Well, what good is questioning the police about the search record or reasonable grounds? Depending on what it is that the police have failed to do, it could be a breach of the PACE codes, Police and Criminal Evidence Act codes, which are fundamental rights, or the failure might well provide an avenue for complaint. A breach of the PACE codes doesn't mean the evidence obtained as a result of the search is automatically inadmissible. There may well be a number of outcomes depending on the facts of the case, but it might become inadmissible. For example, let's say you're being searched. The officer fails to provide his station details or name. The officer starts to carry out a search. You start resisting. Force is used by the officer to carry out the search, and you're then arrested and charged with resisting an officer in the execution of his duty. The result of that would be, because the officer breached PACE by not identifying himself properly, he's not acting in the execution of his duty, and therefore you're not guilty of the offence, because the offence is resisting an officer in the execution of his duty, and the officer wasn't acting lawfully. Another scenario that might involve a breach of PACE is where, for example, the officer fails to give his name, and the search is carried out and a knife is found. Now, that doesn't mean the finding of a knife is excluded. The judge has discretion rather than an obligation to exclude that evidence. And the assessment, balancing those factors, will consider fairness to the proceedings and how significant and substantial the breach is. The mere fact the evidence was discovered during an unlawful search is highly unlikely to render the admission of the evidence unfair. As for complaint, because I mentioned complaints just before, a complaint isn't a legal remedy that will impede a prosecution against you. It's another form of redress like any other complaint procedure. There may be an informal investigation. Depending on the behaviour, action might be taken against the police officer. Some form of disciplinary sanction may be applied. I hope you found this video useful. If you did, there's a load more videos here. Up here, you'll see other videos on criminal law. Over here, videos on family law. Down here, employment law. And here's a video I think you might particularly like. Do please subscribe to this channel. Subscribe and click the notification bell. I'm Barrister Daniel Barnett. Thank you for watching. Bye bye.